In March, the Republican governor of Georgia signed a new law to radically restrict voting rights in Georgia. Just 4 days later, civil rights groups like the NAACP's Legal Defense Fund and the ACLU sued the state over that law. In their lawsuit, they argued, quote, the restrictions in that Georgia law have a pronounced disparate impact upon voters from historically disenfranchised communities, a result so clear that it can only be intentional. It can only be intentional. Well, now, almost 3 months later, those groups are being joined by a heavy, the U.S. Department of Justice, which today announced that on behalf of the American people, it, too, will sue Georgia to block that law. Joining us now is Janai Nelson. She's Associate Director Counsel of the NAACP's Legal Defense Fund. Ms. Nelson, it's a real pleasure to have you here tonight. Thank you so much for making time.
It's a pleasure to be here.
So I hear the echo in your lawsuit from March and the Justice Department's action today, talking about intentionally targeting voters of color, that language in your lawsuit. Today, the Justice Department saying that the law was motivated, meaning the intent was discrimination, motivated by discriminatory purpose. For us non-lawyers, can you help us understand the gravity of that charge and how important it is to whether or not this law is constitutional?
Absolutely. To allege that a law is intentionally discriminatory requires you to prove that the legislators acted with intent, that they were aware of the consequences of their actions, and they intended for those consequences to be so. We know that in the case of Georgia, the particular provisions of this 90-plus page law that evolved over time from something that was just a few pages to this tome that ultimately is one of the worst voter suppression laws that we've seen is a result of legislators effectively examining what worked for Black voters in this last election, where there was historic turnout in both the November 2020 elections and the subsequent runoff elections, and then crafting a suppression bill that addresses the very ways in which Black voters were able to exercise their fundamental right to vote so robustly. So what we see in this 90-page law is a restriction on the time in which you can request an absentee ballot. We see restrictions on the ability of election officials to voluntarily send out absentee ballots to eligible voters to enable them to vote through this well-used mechanism that people have used across the country for many decades without incident. It limits the ability of people to cast ballots outside of their designated precincts and have those ballots counted for the races that have nothing to do with where that precinct is assigned. So there are just particular ways, if you look at the exact provisions of this law, you can see a roadmap to how Black voters were able to exercise their right to vote, and now how that right to vote will be fundamentally denied and abridged.
Do you expect that the Justice Department may intervene in your lawsuit, or that in some other way we'll see these lawsuits essentially become joined? Obviously, you're aiming at the same target here.
Well, Rachel, there are 7 lawsuits, and now with the Department of Justice, 1 additional lawsuit. Many of the lawsuits overlap in their claims, but we represent individual plaintiffs and groups that have distinct interests. So the Department of Justice is operating, as we know, on behalf of the United States government, and the United States government has a distinct interest in ensuring that our elections are free from racial discrimination. We also have a distinct interest as an organization that has worked for over 80 years to protect the rights of Black voters, to ensure that they can exercise the franchise free and fair of discrimination. So we have brought claims of intentional discrimination. We've brought claims about the effects of this law on Black voters, and especially voters who have disabilities. Let's not forget that many of these provisions affect individuals who may face particular challenges in light of the pandemic and in light of limitations that they may face, and that these restrictions make it much more difficult for persons with disabilities to exercise their right to vote. So we represent a very broad class of plaintiffs that is distinct from the interests of the U.S. government. But we are delighted that they have filed this lawsuit, that they are bringing their artillery to this fight. We need all hands on deck. And I think the number of organizations that have sued on this law is a reflection of how deleterious and offensive it is to our general norms and expectations about how we should treat the right to vote in this country. The fact that so many groups are alleging racial discrimination should be a real signal as to how clear it is to so many of us who care so deeply about the right to vote.